5 minutes, please. Thank you.
Okay. This is working this time. Basically, first, I would like to mention 2 points. At the beginning, I was told that we only had 3 minutes, so I tried to be short and not repeat anything that the panel would repeat. The first point I wanted to mention was that when we talk about the fact that we are against Sharia councils and Muslim arbitration tribunals, most people think that we are just promoting women's rights, but this is not the case. We are actually promoting equal rights for everybody, because although it's much easier for men to take advantage of these institutions and dominate women, and obviously children as well, there are ways in which that women can actually take advantage of them against men. This is perhaps one of the reasons that they actually go to Sharia councils or Muslim arbitration tribunals, and the reason is the issue of dowry. I don't know if you're familiar with it, but basically it started many years ago when the husband's family had to pay a lump sum of money to the wife's family, basically in order to buy the woman from her family. And then later it became a sort of investment in case of the fact if the woman had to get a divorce from the husband, he would be liable to pay that sum of money which they agreed at the beginning of the marriage, in order for her to have some money to live on after she gets divorced from her husband. So how can women take advantage of this? Well, basically, I've spoken to a solicitor who had lots of women who've been to Sharia courts, and she agreed that the main reason they went was because they wanted to get this dowry money. What they do is they get their divorce from an English court, every asset, everything is divided equally, then they go to obtain an Islamic divorce, and under the Islamic divorce, the husband is still liable to pay that dowry money. Therefore, the man actually pays a sum of money twice to the woman. So we're not just protecting women's rights, we're actually trying to stop anyone who's going to take advantage of these institutions and get benefit from them for no good cause. The other thing that everyone mentioned was that, I think Maya mentioned that there has been cases that the woman has gone to an English court after she has been to a Sharia, to a Muslim arbitration tribunal, and she still lost the custody of her children. Well, the reason is, first of all, most of these people that perhaps are forced to go to MATs are not aware of the rights that they have under the British law, because they have been coming from different countries, they don't speak the language, or they're just simply forced to take the route that they were shown and not go to any English courts. So what happens is that they go to the MATs, and the children, the custody of the children is given to the father. 3 years later, the woman actually realizes that she has other rights under the British law, and she could actually get the custody of the children. So she applies to the court, but there are factors which courts take into account when they decide in the custody of the children. And as everyone else said on the panel, the child's best interest is the paramount consideration for the courts. There have been cases where the courts were reluctant to change the circumstances of a child's life and get the custody from one parent and give it to another parent, because they would consider that the child has to be moved from one house to another. This means changing the school. This means they're going to lose their friends. They're not going to have the same life that they had, and so on. And they think it's best not to make dramatic changes for children at young ages as such. So that's why even if they go to the courts 3 years later, when they realize what their rights are, yes, it's possible that they will lose the custody of their children. I'm going to move on to the solutions that we have. Most people think that what the Muslim arbitration tribunals do is against human rights, and I've had many people who asked, well, why can't we argue human rights? Well, I've been doing some research, and in order for an organization to be bound by the Human Rights Act, they need to be public bodies. And as far as I've read, the Muslim arbitration tribunals and Sharia councils are not public bodies under the definition of the Human Rights Act. And unless the services that they provide can be classed as services that public bodies provide, then we can actually take them to the human rights courts and challenge them there. However, there has been a new right which was given by the European Court of Human Rights Act, which was if you can collect 1 million signatures from EU citizens, then you can suggest amendments or introduction of new treaties into the human rights policies. So we are actually trying to collect that, but there has been some discussion of who's eligible to sign, etc., which we'll find out later because there is a paper coming. My criticisms of the Act is that it's very vague. It does not actually state exactly which areas of law arbitrators can arbitrate in. So it's not clear whether some government papers, they say it's only for inheritance matters, and some others have said no, they can clearly arbitrate on family issues. So it's not clear, and it also does not actually provide clear definition of who is an arbitrator. Is it anybody that two people can just go to and say, you be my arbitrator with no qualification, no requirements, or do they have to comply with certain requirements? As far as I've read the Act, and it seems like anybody can be an arbitrator, and that's the problem we have, because with the Sharia councils, they often do give out divorce, and when they're giving the Islamic divorce, they actually discuss the settlement under the Islamic laws, and that could amount as arbitrating because the women do not know what the rights are. Another thing I wanted to mention is that, I think I might have 2 minutes, is that when we talk about abolishing MATs, everyone suddenly gets scared and they say, well, it's the right to religion and so on. The right to religion can be restricted for public interest, and we also need to look at the aim, the main purpose of the arbitration. And I think the purpose of it was to provide alternative dispute resolution, which is what government is trying to emphasize more and more these days, and they're trying to keep the matters outside court because there are lots of delays and they're costly and expensive. So basically they're trying to save time for courts to deal with other matters, and they're trying to reduce the costs for clients and the taxpayers. But in my opinion, they have actually dumped their duties on certain imams and religious scholars to deal with matters, and it's not working because, as everyone else pointed out, religious divorce can take a long time to obtain, and they can actually be costly.